Life will never be the same once you learn the occult truth about law. You know that our court systems no longer recognize the Constitution. What we have now is administrative courts. Courts operate under Roman Canon Law 3228. Do you think that these Roman courts operate under any true rule of law? If you said yes, you would be wrong. And this is because these courts operate under presumptions and presentments. When we receive letters, they are known as presentments. This is nothing more than an offer to contract with a private for-profit business. And we have two options. We either accept or rebut this presentment. And under this Roman law, if we do not rebut, this presentment stands as truth in law. It's as if McDonald's started calling themselves the New South Wales government and now start sending you fines and infringements for offences like speeding in their drive-through that now stand as truth in law. It's laughable. We must understand what a presentment really is. It is the act of sending a bill or note for payment. Now we can see that any letter sent to you, be it court summons, council rates, traffic fines, notices, infringements, are all nothing more than a presentment. These definitions are directly from Bouvier's Law Dictionary, and any law dictionary will tell you the same, be it Black's Law or whatever. This is simply telling us what these letters are that are being sent to our name. We don't have to fear them, we have to act on them. Those that are sending these notes, fines, letters, or infringements to you are all members of what's known as the Private Bar Guild. And this bar guild is a for-profit organisation that uses merchant trading principles to commercialise law and profit from legislative offences. And these law societies control almost 100% of the judicial system, and they are the best example of organised crime in history. This is to help you understand that all of these corporations and for-profit businesses sending you letters all work for the same people that control these administrative courts. They are for-profit businesses sending you presentments, which are offers to contract with their corporation. They all do this using the Bills of Exchange Act, sending us notes and offers that we have come to know as rates, fines, bills, and infringement notices for payment. If you're familiar with the Bills of Exchange Act, we can discharge these debts accordingly. However, if you're not, we must rebut them. And to rebut a presumption, first we must understand what a presumption actually is. It is a rule of law which permits a court to assume a fact to be true until there is a rebuttal that outweighs the presumption. Until you rebut that presumption, a court will assume that fact to be true. Each presumption is based on a set of facts paired with logic, laws, reasoning, and individual rights. And each presumption is rebuttable and refuted by factual evidence. What this is saying is that one can present facts to persuade a judge that a presumption is not true. Now, it is quite easy to rebut claims when you know who you are. And a key thing to remember here is that he who makes the claim must prove it. So when we rebut presumptions, we do not want to make any claims, but simply ask questions. When we do this, we put the metaphorical ball back in their court, and they must prove their claims. So you mustn't worry, and the sooner that we realize this, you will begin to have a totally different outlook on law. Now we must understand what a rebuttal really is. A rebuttal is evidence introduced to counter, contradict, or disprove the opposition's presumption in their legal argument. By you learning these words, you will cease to have any fear when receiving these letters or presentments, which are only offers to contract with a for-profit business. Now, a bit of prac. Here is a presentment that I've received in the mail in the form of a letter, which is an offer to contract with this business. So I was sent an offer by Airport Motorway Limited to contract with them. Let's read through it, shall we? Now, at the top, we can see my name in all capitalized letters, signifying they've sent it to the trust. The address below where the trust resides. I just so happen to lay my head at night there, but that is all for another video, I guess. The first sentence reads as such: Roads and Maritime Services has identified you as the registered operator of the above vehicle. Did you catch that? They've said, I'm you, but they've also addressed the letter to the all caps name, John Doe. Are they saying John Doe was driving the vehicle, or are they saying you were driving the vehicle? These are two very different things. Now here, on the definition of you, it is indeed a plural, yet the word you is often spoken as if it were in reference to a singular man or woman. You is often spoken to induce a natural inclination for the audience to hear it as if it were being addressed singularly. As we can see here, the letter was very clearly addressed to John Doe, yet spoke to you within the letter. The corporation sending us this presentment and the courts want us to presume that we are you and not the name that's addressed on the letterhead. This may not seem right to you, but that's exactly what the courts and the law want us to think. But this is exactly how it works. And never presume anything, and always ask through a question to clarify. This is where our rebuttal comes into play, where we write back to them simply clarifying that we are not you. Here is an example of the letterhead of a standard rebuttal. At the top, we have in big red writing, private. This is us signifying that we are sending this letter in our private capacity. And then in the first letter, Mr. Registrar in his private capacity. This is us addressing a living man within the corporation, Airport Motorway Limited, not the corporation itself. This is very important. Within this letterhead, we are clearly stating that we are not you, and we would like the registrar in his private capacity to either confirm who you is or forward this correspondence to you. The second part here is us serving them notice, where we are giving them the lawful time frame of 10 days, where it says receipt of this correspondence shall constitute legal accord and satisfaction of all claims. It would be worth your while to Google those two definitions in a Black's Law Dictionary or Bouvier's, legal accord and satisfaction, so that you understand what it is you are sending. And underneath here, we have separated all parties involved. We have the Crown, which is our copyright last name, and then the sovereign, our Christian names, the names that were actually given to us by our mother and father. And then the private persons. This is all straight out of the Bills of Exchange Act. You should Google these letters. And then we have two witnesses at the bottom. If we ignore, argue, or fail to rebut, we would then enter into what's called an adhesion contract. This adhesion contract doesn't take place between their corporation and me, the living man, but between me, the living man, and my trust named John Doe in all capitalized letters. Once they have their adhesion contract, they can then pursue legal prosecution, where they've prosecuted you, the name, John Doe, the trust, and the living man, all as one. The first letter that they send you is what binds the two parties as one. The second letter is where they claim to have been caused loss, damage, which they will do. The third letter is what they can use to then proceed with legal litigations. All that they are required by law is to show the judge that they have followed due process. What is important to note here is that we can use the same process against them.